Welcome to For the Record with Greenwood Law.
Welcome to For the Record with Greenwood Law and Attorney Dylan W. Greenwood, founder of Greenwood Law in Winston-Salem, North Carolina. Dylan is a criminal defense attorney representing clients in both state and federal court, known for his high-level, personalized representation and hands-on approach to every case. I'm Lisa Mosby, and today we're talking about what really happens behind the scenes of a criminal case, the work clients rarely witness, but that often shapes the entire outcome. Thanks for being with me today, Dylan.
Thanks for having me.
You know, Dylan, people often focus on what happens in the courtroom, but most of the work takes place long before that. When a new case comes in, what does the first phase of analysis actually look like for you?
Yeah, when it gets down to it, court in many respects is just sort of the theater of it all. When you've actually done so much prep and, it's those little detailed tasks that lead up to it for sure. And when a case first comes in, it's so important, and this might seem just like a basic thing, but it's so important to just get a hold of that charging document. What did somebody write up that somebody did? Because I'm going to tell you right now, there are many cases where I get a hold of that and I go, this is just defective. Like they didn't even write this up correctly. This isn't a charge. The things that they allege here don't even add up, to what a potential conviction could be from something like this. So that's step one. Step two is usually pulling the statute related to whatever somebody's accused of. And I say that from the standpoint of, I've been doing this for over 13 years now. And I have done almost every type of case that you can do in state or federal court. Maybe not quite everything, but almost everything at this point. And I still go back and I reference statutes because it's so important to look at those details relative to the specific details in someone's case. And then the other important thing is to go ahead and do whatever you can to ascertain as much discovery as possible, even before you can get it from a district attorney's office. One, because not every district attorney's office will give it to you because North Carolina has a law that says you're not required to have discovery at the district court level. You are at the superior court level, but not the district court level, although most people will give it to you. Not all, but most. The second thing is can you get a hold of pieces of information ahead of time? Because maybe you need to subpoena videos quickly, like surveillance camera footage, or you need to get an investigator involved quickly to get a hold of somebody's statements that maybe, every day or hour that goes by, their memory fades a little bit. And so getting something kind of quick can help, just depending upon the situation.
You're talking about a lot of discovery. How do you approach reviewing all that material in a way that keeps the important details from getting lost?
That's an excellent question. That is a part of my job that has morphed over the years. The amount of discovery has grown exponentially. Routinely, for instance, in a federal case, we're asked to give 2, 3, 4 terabyte hard drives to get that much discovery back. And a lot of times it's camera footage and surveillance footage and all that sort of thing that you got to go through or figure out how to go through. Sometimes it can be talking to an attorney involved in the case, like a U.S. attorney, and saying, hey, okay, I see that you've sent me the whole conspiracy's worth of evidence here. What do I need to look at as it relates to my particular individual? Can you at least give me a head start? And then I can go from there as to what seems to be important or applicable. There are also companies that organize massive amounts of discovery that can help you get it all corralled in a way that it's a little easier to digest. A lot of times we have access to those in a federal case because of the amount of discovery, and we have a little bit of a budget if it's a court-appointed federal case to be able to send that out to do that sort of thing. The other thing is you kind of learn to, at least initially, weed through the subpoenas and warrants, like if it's a search warrant, or the initial reports that seem important, because a lot of times what you're doing in the immediate sense is looking to see, is there something else you need to investigate, and what do I need to use for a potential argument on bond? And being able to discern and pick through that surgically can really, really help. Ultimately, you're looking at the whole thing, overall, but initially, that's what you're looking for.
And many cases turn on small inconsistencies. What kind of patterns or gaps in reports tend to get your attention early on?
So I love to see the initial reports compared to the later supplemental reports, especially if somebody involved in a case that's a potential witness, an alleged victim, they're going and they're making multiple statements, because if they have inconsistencies in those statements, that's something I'm going to key in on. And every opportunity somebody has to talk is an opportunity that maybe they're not going to remember everything correctly, or maybe they're going to and over explain or make indulgences in their recounting of whatever occurred. And then obviously, as time goes on, memories fade. They're not as good. But then other pieces of information are very important, like if somebody's made particular notes about the things that they observed, or they've journaled about it, or whatever it may be, or you have business records, that sort of thing. I'll also look pretty early on if there's video. There's so much video around in the world now. Everybody's got, a camera, just about. And there's so many times that something can happen and immediately people are pulling it up and they're doing this. And sometimes you can get a hold of those videos. It can make a difference one way or the other in a case. Surveillance camera footage. I had a case one time where this individual was accused of a drug-related offense. The officer pulled this individual out of a car in a very aggressive way, got her down on the asphalt of a parking lot, and drug her across the parking lot. And there was no reason for that to occur. And we were able to pull that surveillance camera footage by figuring out where this was very quickly, going to that location saying, hey, do you have it? And they had it, but it hadn't been deleted yet. And we were able to put that in front of a DA and say, hey, this case can go one way or the other here. What you pick, basically. And nobody wanted that camera footage to come out. And so that was able to really, really affect that case in a positive way for my client.
So, Dylan, do you often work closely with experts in certain cases? If so, what leads you to bring in like a forensic psychologist or an analyst or some other specialty?
We do that quite a bit, especially in particular cases where it seems pertinent. We've done it in cases where the person that we are representing might have significant mental health issues, and we believe that those mental health issues were a prevalent cause or aspect of what they're alleged to have done and why they're under scrutiny by the court system. So getting a forensic psychologist involved as early as possible is usually extremely helpful, because then they can do a particular type of analysis to discern whether or not somebody was of a proper state of mind, or of had all their faculties to actually commit a crime free of any type of mental impairment. And that's a big analysis. And we've had a couple of significant cases like that within the last year or so that really turned on what a forensic psychologist was able to produce. It's almost a standard thing at this point that we do in sex-related cases as well. I have found that DAs, judges, juries, they want to know kind of like what's going on in somebody's head. And that's kind of the way that we have at this point to sort of peel that back and see what's going on. And there's a lot of different ways that a forensic psychologist can discern whether or not someone's being forthcoming or they're trying to be deceptive, almost like a form of a lie detector test in a way, that I have found really can push a case one way or the other with what the outcomes are. Other experts that we look at pathologists, especially in DWI cases, to look at potential drug interactions. That's weighed in heavily on cases. One time I had to find a chicken expert for a cockfighting case that could tell me everything I needed to know about fighting roosters, because I didn't know anything at the time. Now I know a lot, but at the time I didn't. You can find an expert on almost anything, and sometimes it can just be enough that they're telling you information that you need to know so that you can kind of talk about a topic in an educated fashion, or sometimes you just need them to come in and testify or to, draw up a report that might sway a case one way or the other based on their findings.
So can you describe a moment from a past case where something uncovered during the behind the scenes investigation shifted your entire strategy?
So I've seen that go both ways. Sometimes it can be a thing that we uncover that all of a sudden investigators go, oh, we really got this wrong. We need to back off. So I've had that happen where somebody was being investigated for something very serious, but we were able to uncover the fact that there was significant money and different dynamics among people that caused these accusations to come out in the first place, and they were not founded. There was nothing to back them up. And then on top of this, you had this huge bias and this reason why somebody might be mad at somebody to cause them to do that. We were able to uncover that, put that in front of an investigator. They were able to corroborate it. And then all of a sudden, charges aren't being brought down. Obviously, that takes a particular individual to do that to somebody, but they're out there. I've also seen it go another way, where I was involved in a case that involved very, very, very sensitive material that you shouldn't have. And my client, we had been in this investigative phase for years, actually. And basically our story was had gone a certain way that, it didn't really involve him, and involved other people. There was ways to access these materials that, didn't really necessarily point to him. It could point to other people as well. And those were legit things. But then a certain investigator, and somebody that I actually respect a great deal, in part because of that case. I mean, he really did thorough work. He did good work. And we all sat down together. And he just started pulling things out. And I quickly started reading the writing on the wall. And I had to take my client in another room and have a very difficult conversation with that individual that was very to the point and no nonsensical of we need to shift here because the stuff you're telling me is not lining up now, and there's concrete evidence to show otherwise. And if we want to prevent certain really not great things happening to you, like potentially going to federal court versus state court in this type of situation, or me having the opportunity to maybe preemptively work out a deal for you where we know it's going to go a certain path, I was like, your rhetoric needs to change. And all of a sudden, I mean, that took the better part of about 3 hours, but it shifted that case. And that individual went from staring down the face of going to federal court and going off to prison for an extremely long time to then being able to being prosecuted in state court and getting probation.
And you talked about rhetoric. When you talked about rhetoric there, preparing a client or a witness is a careful process. What does that preparation usually involve, and why does it matter so much?
Well, it matters because what someone tells me can matter, because if I put them up on the witness stand and all of a sudden they say something entirely different or represent something entirely different to the court, and it's potentially perjurious, then I'm under a duty as an officer of the court to inform and say, hey, this is like, I'm concerned that perjury has occurred here. Okay, that's always creates a unique circumstance that you really want to avoid, and thank goodness I've been able to avoid that in all but one occurrence in my career. It happens to everybody at some point as an attorney. But that really matters. It also really matters prep-wise, because if I put someone up on the witness stand, the other side's going to have the opportunity to cross-examine them. And when I cross-examine somebody, I take different strategies on it, but a lot of times I'm coming after you with very fact-driven questions, one after another, yes, no, and it's a way that I am asking them in a certain way to, there are certain strategies there that you take in cross-examination to get somebody to, admit to things that they didn't necessarily want to admit to on direct. Because when you're on direct, you get to kind of just open-ended answer things that you want to say, and you have the ability to make your narrative look a certain way to look as best for you as possible, right? You don't want somebody to look badly upon you. But then during cross-examination, when me as the attorney, I know more details about a case because of discovery work, investigative work, what have you, or even just reading between the lines on a report and being able to say, hey, here's this, here's that, here's this, here's that. And that means that, this didn't actually add up to this, right? And then they're in a point where they're like, yeah, okay, maybe it didn't. I might. And so, okay, so you embellished here on direct, didn't you? That's, that stuff matters. So, to prepare your client or a witness for that occurring on the other side, where they're going to get peppered with those types of questions, that can make or break a case.
And court calendars in North Carolina can be crowded and unpredictable. How does managing the timing of hearings, motions, and negotiations influence the direction of the case?
Yes. So that really depends on misdemeanors versus felonies. In a misdemeanor case, it's in district court. It can be continued for any number of reasons. I've seen cases be continued for years, even in district court, especially like DWIs, because of like blood being, coming back from the state lab, or, you're waiting for a chemical analyst to be available to come in and testify, whatever it may be. There are certain strategic things there, because, when it gets down to it, the further something is away from the date it occurred, memories fade. That's an aspect of a case. And I don't think I'm really shocking anybody by saying that. In a felony situation, there are stricter deadlines, to be sure, especially once it gets to Superior Court. So there are different settings and different calendars for Superior Court. It can be on an administrative calendar versus a trial calendar or a motions calendar or what have you. And you've got to file stuff by certain dates to be able to preserve like certain issues. And, that can really affect potential outcomes in the case, because, it might affect the type of plea you get. Sometimes people think that the first plea offer that you get is the best one. I'm not always convinced of that. There's usually room to negotiate. And sometimes things that you file, sometimes things that happen with witnesses, sometimes just case going on and on and on, or the prosecution of a co-defendant, whatever, might affect some sort of follow-up conversation about how a case might get disposed of. So all that timing, you do your best to sort of play this like mental chess game about it and predict. Ultimately, you can't predict the future, but just based off of experience and seeing cases day in and day out, sometimes you can kind of get a good idea of how it might shake out.
And as a case develops, what helps you determine whether it's heading toward a negotiation or a motion to suppress or trial?
Sure. Not every single case are we necessarily trial prepping on. Like a speeding ticket. We're not going, hey, we're going to take this to trial. It's not exactly the case. But a lot of cases, you start off with the mindset of, well, we're in trial prep mode. And the reason why is because if you're doing it from a perspective of prepping for trial, that might be how you ultimately get your best outcome or your best plea offer if it is ultimately going to plea. And the reason why is because when you do trial prep mode, a lot of times you're finding deficiencies in a case. You're figuring out inconsistencies from witnesses. You're figuring out things that maybe good things that your client's doing or have been up to that people aren't paying attention, or you figured out alibis because again, you've been in trial prep mode. Sometimes though, it's very clear from the get-go, you're not there. You're trial prepping for trial is not what is needed. Trying to get the best outcome is what is needed. And you can still try to look for those deficiencies or some of the weaknesses in a prosecution's case, but maybe the strategy shifts from doing that to maybe pulling in what's called like a mitigation specialist, where somebody's coming in and they are figuring out all the great things that your client is doing, or maybe trials and tribulations that your client has been through throughout the years, or maybe they have adverse childhood experiences that nobody knew about that then like led them to be at a certain place. And then all of a sudden you can use that as this like portfolio of who this person is to take a case from being a number and a file for a DA looking at to actually have a human being associated with it. And telling somebody's story in that way, I think, matters significantly for potential outcome.
Dylan, this has been valuable information. Thank you so much for sharing your insights. And folks, that's it for today's episode of For the Record with Greenwood Law. If you'd like to learn more about Attorney Dylan Greenwood and his work at Greenwood Law, visit dwg-law.com. You'll find helpful resources about criminal defense in North Carolina, from state charges to federal cases. Thank you so much for listening. And don't forget to like, leave a review, and share this episode with someone who might need it today. And come on back.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.